For the board's review today and today's public hearing. At this time, I would ask everyone to either turn off their cell phones or put them on silent so as not to disrupt today's meeting. The procedure will be to introduce the case record. We will present site plans, photographs, and maps of the properties involved in today's cases. We will also present any letters we have in support or opposition to the particular case, as well as any correspondence we've received from other governmental agencies. At the conclusion of our presentation, the appellant will present their case to the board along with any person in support. If there is opposition to a case, the board will then hear from those parties. After the opposition has presented their testimony, the appellant will have a period for rebuttal. The board, in their rules, provides the appellant, in cases without opposition, 10 minutes for the applicant to present their case. In a contested case, the board provides 15 minutes for each side to present their testimony. Should the appellant wish to provide rebuttal testimony, the appellant should reserve some of their allotted 15 minutes. All section numbers that we refer to today come directly from the Metropolitan Zoning Code, which was adopted by the Metropolitan Council and became effective on January 1, 1998, and applies to the entire jurisdiction of the metropolitan government. I'll introduce and make part of the record the entire zoning code, and will dispense with the reading of individual sections unless the appellant or opposition requests the reading. The zoning code requires that these proceedings be taped. Therefore, it's imperative that anyone addressing the board come forward, speak into the microphone, identify yourself, and then make your presentation. It should be noted that if it is found that anyone has presented false or misleading testimony to the board that would have affected the board's decision, any approval may be revoked at a later date by means of a show cause hearing. The board will go through all cases set for today's public hearing. After each case, the board will discuss and vote on that case. The board is vested with the power to act on these cases before us today under the following provisions as outlined under the Metropolitan Zoning Code, Section 17.40.180. The code requires 4 members of the 7-member board to be present to constitute a quorum. The code also requires 4 affirmative votes to grant your application. As everybody sees, we have 4 members here today, so it's going to take a unanimous decision in all 4 votes to approve the request. In the event that there are only 4 members present and there are not 4 affirmative votes, the application shall be re-advertised for the next available public hearing cycle. In the event there are 5 or more members present and there are not 4 affirmative votes, the case will remain on the board's agenda for the next 30 days. Applications that fail to receive 4 affirmative votes within 30 days of the public hearing shall be deemed denied by operation of law. The appellant or any aggrieved property owner may request a rehearing within 60 days of this public hearing. Further, the appellant or any aggrieved party or property owner may also appeal the board's decision to the Chancery Court within that same 60-day period. After that time has elapsed, the board's decision becomes final and no further action can be taken. If you are an appellant and your case is granted, it will be necessary for you to obtain the permit for which you've applied. It should be noted that a permit must be obtained within 2 years for the board's approval to remain valid. I submit that all cases have been filed in their proper order. All appellants have been notified by certified mail as required by the code, and affected property owners have been notified, and the legal ad has been published in the Tennessean as required by the code. Now is the time that I call for any elected officials, and I see Councilman Todd is here today. Councilman Todd, you're welcome to speak now, or you can defer your comments until the actual case is called at your pleasure.
I'd like to go ahead and speak now.
Yes, sir.
My name is Carter Todd. I'm one of the council people for the Green Hills area of Nashville, and I'm here today to speak on the application by Tommy Sidwell for a setback variance at 1103 Nickel Lane. I think this is the second case you all will hear. First of all, I want to apologize for taking your time. There are a lot of people here that want to speak today, and I tried to get everybody together and talk about a compromise or settlement, but I really don't think this is a case that can be settled or resolved. So unfortunately, it's going to come before you all today, and you're going to have to sit through all of this, which is good for you all every now and then. So, after meeting with these neighbors, and you're going to hear from a lot of them today, I believe they are united in their desire to not grant the setback. The applicant notes in his request to you all that his hardship is a creek in the backyard and that the setback will cause no injury to the neighboring property. After listening to all these neighbors, I've listened to them, and I think you all will get to hear them today, I would have to disagree. I really do believe that not requiring the builder to comply with the existing setback for this street will harm the other property owners by hurting their property values. My district, the 34th district, which is out in Green Hills, is somewhat unique compared to the other 34 council districts. I have 2 satellite cities in my district, and in addition to Oak Hill and Forest Hills, which I have in my district, I also have the city of Belmead, which I don't have any of, but my district surrounds it completely. This causes some unique zoning issues in my district because I've got cities like Linwood Boulevard, beautiful street. Linwood is half in Belmead and half in my district, half in Green Hills Metro. And so you've got 2 different codes administrators and 2 different zoning bodies that deal with a street like Linwood Boulevard. Here in Nickel Lane is the exact opposite. Where one is the east side in my district, here I guess the west side is in my district at Nickel Lane. It's interesting, houses on streets like Linwood Boulevard and Nickel Lane generally sell for more than houses in other streets in my district, in part because I think they face one of these satellite cities with restrictive zoning. And so these people, when they buy their homes, I think they have an expectation that whether it's right or wrong, that the codes and the zoning is going to be enforced the way it was when they bought their homes, which I think is a reasonable expectation. You know, in zoning and codes work, we always talk about transitions and stepping down, you know, where you have high density, you move to lower density, you move, and I think when you have a satellite city right in the middle of somebody's council district, I think the same should be true, that you kind of need to gradually move down, where a street like Nickel Lane, where maybe you keep kind of rigid zoning, but if you move over to Page Road, which is, I guess, parallel to you all, you can be a little looser, and then when you move over even further, you know, you kind of transition away, which makes sense as you step down. And so I think that's reasonable, rather than to have an abrupt change where you've got all of these beautiful homes with the same setback on this tiny little beautiful street in Green Hills. Then you just abruptly have one jut out. I think that was, and it may be 2 homes jut out. It will just, I think it will really stand out like a sore thumb. So for this reason, I think that these neighbors will suffer a real financial loss if you all waive this variance today. Nickel Lane is one of the treasures of Nashville, and I think it would set a horrible precedent for this street. I want to thank you for your time today, and I apologize that we couldn't work this out. We really tried. We had a meeting, you know, and we worked hard to do it, but it just couldn't be done. So, but thank you.
Thank you, Councilman Todd. Do we have any other preliminary announcements from the board? Seeing none. The board has a consent agenda. A board member reviews the record in each case prior to the hearing, and if in their opinion the applicant meets the criteria for the application requested and they feel testimony in the case would not alter the material facts, they recommend the case to the remainder of the board for approval. We will enter into the record those cases that have been recommended, and if there's anyone opposed to the case, please raise your hand and the case will be removed from the consent agenda and heard in its regular order. Skipping back very quickly to a couple of preliminary announcements so everybody knows. The first case, case number 2015-012, has been deferred. If there's anybody here on that case, it's been deferred. Yeah. The next case on the agenda is case number 2015-024. It's John Sundock. It's the case on Woodmont Boulevard. It has been withdrawn. If there's anybody here on that, that case has been withdrawn. The next case on the agenda is case 2015-033, Bethel World Outreach. That case has been deferred, and I believe it's deferred to June 4th. Now, moving to our consent agenda. The first case that we have slated for the consent agenda is case number 2015-040. It is Nate Roach, appellant, and Larissa A. Noralt owner of the property located at 1803B Stewart Place, requesting a variance in the rear and side setbacks and rear buffer yard in the R6 district to construct a new second single-family residence, two-story, to the rear of the existing residence, a second dwelling on the lot. This has been referred to the board under Section 1712-020A and Section 1724-240C. The appellant has alleged the board would have jurisdiction under Section 1740.180B. This case is backed up to some some industrially zoned and used property. This case principally involves a rear buffer yard. We've had no opposition to this case, and we would ask that case to be on the consent agenda. Is there anybody here who is in opposition to case number 2015-040, Nate Roach, for the property on Stewart Place? Seeing no opposition. The next case slated for the consent agenda is case number 2015-041. This is Zach Provenoci, appellant and Urban Housing Solutions, owner of the property located at 2121 26th Avenue North, requesting a special exception for the street setback and height in the RM15 district to construct a 23-unit apartment building. This is referred to the board under Section 1712-060F1 through 1712-030.01. The appellant has alleged the board would have jurisdiction under 1740.180C. Members of the board, this case, we've received a letter from Council Lady Lancaster that is in support. We've also received a letter from Councilman Harrison, also in support. We've received verification that they've had the neighborhood meeting as required for a special exception. We have received the recommendation from the Planning Department recommending approval of this, and we've also received the recommendation from the Department of Public Works taking no exception. Is there anyone here in the audience that is opposed to case number 2015-041 for the property located at 2121 26th Avenue North? Seeing no opposition. The final case that we have for the consent agenda is Kelly Longenecker, appellant, and Kelly A. Clark, owner of the property located at 4523 Beacon Drive, requesting a variance to the side setback, 15-foot required, requesting 8 feet in the RS40 district to construct a 328-square-foot addition to the side of an existing residence. This is referred to the board under Section 1720-020A. The appellant has alleged that the board would have jurisdiction under 1740-180B, and this is case number 2015-042. It's the irregular shape of this lot that is necessitating the variance in this case. Is there anyone here in opposition to case number 2015-042 on Beacon Drive? Seeing no opposition for the board, I would recommend Chairman King has recommended these cases to the board for consideration for the consent agenda.
I'll second.
We have a motion and a second. All in favor of the discussion? All in favor, say aye.
Aye.
That passes. So if you are here on any of those cases that I just called for the consent agenda, you're free to leave. And you can come by our office on Monday and pick up your permit or a copy of the order if necessary. Moving to the first case that we have on our agenda for today. It's case number 2015-035. It's Eric Mallow, appellant, and Leslie Brown, owner of the property located at 477 Chestnut Street, requesting an item D appeal in the IR district to construct a 320-square-foot addition to the side of the non-conforming residence. This has been referred to the board under Section 1740-660C. The appellant has alleged the board would have jurisdiction under Section 1740-180D. The appellants are free to come forward and make their presentation. Is there any opposition here on this case? Okay, seeing opposition. So folks, you all will have 15 minutes to make your case. You may want to reserve some portion of that 15 minutes as rebuttal, and you may proceed. First of all, if you don't mind, let's let Mr. Harrison go through the record that we have it from our department, and then we'll allow you to go forward.
Okay, the property is located on the east side of Chestnut, just north of Humphrey Street. This is a site plan. We've had another site plan submitted, which you've got in your packet. That's they've drawn their site plan on the survey that was submitted by the neighbor and shows their addition. For whatever reason, this computer had some problems, so it's not popping up on here. But that's the proposed location of the addition. That's the building looking at it from the front, from Chestnut again, from the front to the left. That's looking down where the addition would be on the left-hand side, the right picture. That's looking at it from Humphrey Street, and that's looking across the street towards Old Greer Stadium, where this is across the street from. And that's the record we have.
Okay, it sounds like you all may have submitted a revised site plan. We received a copy of it, and the board members also received a copy of it. For some reason in our computer glitch, it is not popping up in our presentation. If you want to introduce a new copy of that or show it to the board, you're welcome to do so. And folks, you can go ahead with your presentation.
Good afternoon. I'm Eric Malo. I'm here on behalf of John and Lauren. They're proposing to add a very small addition to their house, only 320 square feet. They're expecting their first child. It'll be a nursery for their child. We were here several weeks ago, and you probably remember. We have requested a survey to be made. That's still pending, given the atmosphere right now. Surveyors are completely backed up. But what we've done is we've taken the data from the neighbors survey, who is in opposition to this addition, and we have shown how the addition does not encroach upon their proposed property line. It is 4 to 5 feet away from their proposed property line, which is still, it is not consistent with the deeds of either property. And so we do not agree that that's the property line, but we feel that this is a completely separate issue. Basically, we just want to show that the addition is not encroaching on either the deeded property line or the argued proposed property line.
The proposed addition, not the current addition that they're saying is actually the encroachment.
What is the required side setback on that side?
It's a 0 setback, given that it's an industrial zoned district.
So either way, you would not be crossing the property line.
That's correct.
Okay.
Correct.
And that's what we really want to demonstrate, that these are separate issues. They've wanted to present these as connected issues. Frankly, because we are in the middle of legal proceedings about a separate issue, and frankly, we feel that that's kind of been presented as leverage so that we have to deal with another issue with them, but really they're separate issues per the letter from our attorney.
So is your position that your existing structure does not encroach?
That's correct. In addition, our position is that that's a separate issue to requesting for an approval to the addition. The new addition clearly does not encroach.
With all due respect, I have a hard time separating the two issues. If you're, if under one scenario you're already encroaching, then that leaves a bit of a sticky wicket to deal with, I think, later on. And we're being asked to give a variance of how much on the new addition?
It's an item D. It's a
non-conforming use.
Non-conforming to non-conforming, so it's not, there's no variance at all.
Right, okay.
We're here before you today simply for the non-conforming use. It's only the opposition of the neighbor that has brought up other issues which we find to be irrelevant to the matter of the non-conforming use. And therefore, we feel this isn't the right forum to debate or discuss those other issues. And as Lauren already mentioned, there have been conversations between each of between the lawyers to discuss that separate issue.
So
How long has this house been there?
Before any of the other properties, the other buildings around it. Do you have a date?
It shows up first in 1897 on the map. The addition is about 6 years old. They're the one they're talking about.
Can we go back to the pictures again? I think we've gotten away from, it's an item D.
Exactly.
And we've gotten away from that. But with an item D, you need to explain how the change or enlargement would result in less of an impact on the surrounding area. So I'd like to hear a little bit more about that. And I think the pictures would help.
The neighborhood is very mixed use. There's residential adjacent to industrial properties. There's commercial mixed in, all sorts of different types. The zoning is very non-continuous in various parts of the neighborhood. So we enjoy, most of the residents and neighbors in the neighborhood and businesses alike enjoy the varying types of uses in the neighborhood. John and Lauren's house is a residential use on a now zoned industrial site. A small addition of 320 square feet, a single story, setback from both the property line and the street, has very little impact on the neighborhood whatsoever, far less than a very large multi-story industrial building, which is what's on the neighbor's property, as well as many other industrial buildings in the area. But it's nearly inconsequential in scale and scope compared to adjacent properties.
Which is also why we submitted, I think it was about a dozen letters of support from our surrounding neighbors who have a lot of social capital in that direct neighborhood, where we have personally served in that neighborhood, and he continues to serve on the board.
The letters were from a variety of neighbors, including residents, business owners, property owners, across the street, diagonally, quite a few well-known citizens.
I'd like to ask our council to read the standards for the item D approval, please.
I am actually in the process of locating those. Well, he wants the standard. Okay. Under Metro Code of Law 1740-650E, the board would have to issue the permit finding that the floor area ratio expanded together with all the other uses of the lot will not exceed the floor area ratio currently permitted. And let's see. Also, that the new non-conforming use will be more compatible with surrounding land uses than the existing non-conforming use. So those are the things that you're looking for.
As always, vague but profound. Thank you.
I could add one thing to that. Do I need to press there?
Yeah, I think so.
We'll also be getting rid of the outbuilding on the survey, and it's closer to the street, so all that storage would now be included in the addition. So we'd be further back from the street, if that's any consolation.
So you said the addition was about 6 years old, and it was there when you bought the house? Or you did the addition?
I did the addition when I owned it. The house is now in my wife's name.
To add to that, maybe to clarify, is there's an addition that's 6 years old that has been brought up in question regarding the property line issue. That's not what we're here for today. We're here
I understand what your position is, but
for a new addition.
But
I understand.
We're dealing with, is the proposal more or less non-conforming for whatever reason? So I think all the existing condition is applicable, and that's why I keep asking about it.
Questions? You'll have 12 minutes rebuttal time after the opportunity. You want to hear from the opportunity?
Should I start?
Yeah, go ahead and introduce yourselves, if you will.
Oh, I'm sorry. Yes. Speak. Okay. My name's Kirk Francis. I'm the owner of the industrial building in the property next to the Browns property. That is not a current picture. We do have a warehouse that's actually there. Now, that's actually current, that other one. But we contest this because basically we understand that there's two separate additions. The initial addition was done without a survey. In fact, I'd rather not be involved in this at all, but I got involved when I was building our warehouse because we needed some more space on for our building, and we had a survey done, and it showed that they were on our property with the original addition, and we decided to get a more detailed survey, which we gave you a copy the last time we were here. I hope you still have a copy of that survey. And we also brought the surveyor with us, so this is the person who actually did the survey. And I submit that none of this we wouldn't even be here today if he had gotten a survey in the very beginning. I think this would have been avoided. But having done the more detailed survey with the engineering report, we found that not only are they encroaching on our property from the original addition, which we discovered last year, we also are seeing that the survey is showing that they are not following the setback lines, and they have not provided an actual survey. I haven't seen anyone that's licensed in anything presenting their case, and we submit that in this second edition it's not complying with the setback and the actual right-of-way. So I'll defer that to my surveyor to answer any questions about that.
Hello, I'm John Duffer with James Plus Associates, and I am the surveyor that they did. So.
Julie Thompson. I work for Mr. Francis.
Do you have questions for him, or do you want him to explain with you? I don't know.
Well, I mean, I don't know. I mean, I guess what we'd asked for last time and what we talked about was if your survey was the neighbor's worst case scenario, and it were true, and I'm not here to say it's true or not true, and I personally don't think it's applicable to what we're trying to decide today. Others may differ, and that's fine. I mean, everybody, but you know, we said if that were true and this addition didn't encroach your property, then I guess why do you have a problem with it still? And I think that what the applicant in their drawing tried to show was that it wouldn't encroach your property. And so my question is, again, because this board is not charged with the property dispute line, I don't think we have a dog in the hunt.
Right.
But we are trying to decide, is this addition, more, basically, does it add any more incompatibility to that, to the zone? And in my opinion, I don't know that it does, but I think if you feel like it encroaches your property, you have a case, but their drawing shows it doesn't. So tell me what your case is.
You want to explain?
I'll explain that. I mean, we have two different exhibits from them. The one that didn't show up, they actually took a piece of my survey and put their building on there, which if it's drawn correctly, I don't, which hopefully it is, but I don't know. We didn't survey it. So somebody just put it on my survey, and it shows it does not encroach. The actual site plan they submitted, their A1 exhibit, I believe has property line incorrect, and it definitely has the right-of-way along Chestnut Street incorrect. It's not up behind the sidewalk. It's much further down. I don't know if the 15-foot setback is important or not, but if it is, it goes through about a third of the proposed addition. But as I said, maybe you could get a variance on that too. I don't know.
But that property, that's not on your side of the property. It's the Chestnut side.
No, sir.
Right?
I'm just mentioning what's valid on the property line or not. It doesn't affect me personally anyway. So. I did actually survey both properties. I did the whole block from Martin all the way down because it was a dispute.
And my goal is to not get into issues that we're not, that we really don't need to be getting into, And so, to me, those are the types of things that, the independent surveyors and the courts and can figure out the property line. But again, back to, it sounded like you said that in your belief, the Chestnut side might encroach. That's something that they can deal with codes, but your property line wouldn't encroach with the building that they proposed.
If they've drawn it correctly on my survey, it doesn't.
And do you see anything that indicates it's not drawn correctly, or?
Well, I don't know. I mean, I don't know. I mean,
It's not an actual survey. What they've drawn is they took his survey and created something to fit what they wanted to do. All we're asking is that they do an actual survey because it's not showing the actual setback line. There's nothing that we've spent a lot of money to get two surveys done and do the research to just show, to try to find out the actual boundary line of the property. That's what we're trying to do. And, obviously we do have a separate case which we're trying to get resolved. We have made an offer or asked them to make an offer to us to resolve the issue, but we have not heard back from their attorney. I don't know why. My attorney, I saw the letter that he sent to you. I totally disagree with that letter, but he has not gotten back to our attorney, who asked over 2 weeks ago for them to make some sort of an offer or try to work it out with us. When we left this board the last time that we were here, Mr. Whitson said that for them to get a survey and try to meet with us and work through these things, and that has not been done. All that they've done is actually taken our survey and rewritten it to fit what they're trying to do on this property. I don't wish anyone ill will. I don't wish any, I would like to move on and put this behind us, but the problem is that they just went ahead and built the property in the first edition without a survey, and I wouldn't even be here, like I said, if they had done this gotten a legitimate survey then. They still don't have a legitimate survey, and the board here asked them to do that, which they still have not done. I understand there's a lot of construction going on in Nashville, but I don't know. I understand you have to base your decision on this second edition. I completely understand that, but based on what his survey shows, and we had a way more detailed survey done, an engineering report, and it shows that their property is actually, the property line, the setback line is actually further back than what they're showing on that. So they're actually building an addition that doesn't follow the right setback law. So all we're asking is that they just get a survey. If it falls in line with the survey and what we've surveyed, and I don't have any objection to that. But I do want to try to get our issue resolved as well. So it is a separate issue, but it's still the same property.
So I think you just said, just to restate, that if they build the addition and it's on their property, then you have no opposition as long as it's on their property?
Well, the only opposition I have is if they're not following the laws of the setback line, and again, they've never gotten a survey. There's also an issue of traffic. So as long as it's not a really high structure, I mean, as you can see when you go around that curve, there is, if it's a high, and they've built that, the house part is so high, you know, I'm afraid if it gets really high out in the front there, we wouldn't be able to see as we're pulling out of the building. So
they testified it was a one-story addition.
That's fine. That's fine. If it's small enough, if it's not in the way, then we just want to make sure that they're following whatever the actual laws say that they should, and that's why I just asked that they get a survey.
Well, and I don't know if a survey is required or not. The codes folks might help us, but it seems like to me that that issue is something that the codes inspectors determine and not us. I mean, we would say, I mean, I think there's always an assumption on what we rule, and that is if it follows those rules, then it's okay. I mean, I don't think they're not asking for a setback at all. So that would have to, they would have to work with codes to make sure that they're within those guidelines. But that's the normal codes process, not what they're asking.
But
from us
codes
today.
is also assuming that their information is good. Codes will check it, but codes isn't going to go survey to see if they're in the proper location or if their drawings are accurate. I mean, if they had a survey, codes would be putting their faith in the stamp of the surveyor, which is regulated by the state, and would have no reason to think that they were in the wrong position if their drawings showed it to be correct. So that's my problem. You know, I don't understand why there's not a survey, and it seems like that was the one thing we asked for last time.
And exactly what you said is what I've been arguing. Their codes in the beginning, I don't think they actually got a survey when they did the first edition, and that's how it ended up on our property. And I just want to get this done the right way, and believe me, we want to resolve this. I really do. But I have not been able to get any kind of resolution with them, and all we're asking is that we do this, help us to follow the process that it's supposed to be followed, so that they're actually, if they're going to build an addition, that it's following the correct guidelines.
We'll certainly seek that answer on rebuttal. And this body is not empowered to grant them the right to cross their property line. And that's not to be inferred anywhere. Whatever this action has, they have to abide by the codes, by the laws. So please understand that. Our position is not to grant a crossing of the borderline. So, anything else to add?
Do you have anything to add?
No, sir.
Let me ask you a question.
Yes, sir.
Out of my own experience. I have a property and I had it surveyed. Had a great deal of money. Surveyor came back and said that I was like 12 feet less in the width of my property than the original survey showed. Who settles that when two surveyors disagree on something? Where's the answer to that?
Usually, well, if neither property owner can agree, it has to go to Chancery Court. Surveyors cannot establish property lines, only mutual consent of the owners or a Chancery Court judge. So if surveyors, do disagree from time to time, it's actually a surveying joke that you go out and there's 3 iron pins at the same corner and you put a 4th one in the correct spot. So,
well, and that is a good point. I mean, I've lived in my home 20 some odd years, and I've had a couple of surveys, and sometimes it's shifted over a foot, and sometimes it's shifted back 2. And thankfully, I've not had any neighbor disputes. But that is a good point, and not that any of those surveys were done professionally and with goodwill and good faith, and I'm sure yours was too. And
now, in this case, we did survey the entire block because we knew going in there was a dispute. So we surveyed from Martin all the way down, and actually researched back to 1866 when the subdivision was created, and found the original division. And apparently there was an encroachment. There was a deed that was in error, like parcel 142 was 3,100 square feet. Now it's about 44 square feet without buying any more property. But that doesn't affect the Chestnut Street. But I even found there might be a 12.5-foot strip between the 2 properties that still belongs to John Moore, and it was theirs. Doesn't affect the Chestnut Street, but the new addition may be on that, I don't know.
Interesting detective work, right?
And land apparently doesn't shrink or expand over a period of time, does it?
It's not supposed to.
Were you able to find an area around this property, were you able to find the markers that were called out?
No, sir. I mean, the only markers out on 142 were back in 1867 or 1868, and they called for a stone and a cedar stake, which were not there.
So no pins or anything like that?
We found some PK spikes and an iron pin down at Martin Street and another iron pin set up near the intersection of Humphreys. None of them are original markers. They've all done by surveyors between, say, 1983 and the present.
Thank you.
But most of it was based on, took the original plat. You know, we did have the right of way for Humphreys and the alley and Martin Street and Chestnut and T-Dot plans. And then took the original plat from 1866 and superimposed that to fit the preponderance of the evidence, and that's how we came up with the boundary. And in this case, one of the rare ones, the good signs, we had all the property it's supposed to. Lot 21, which is the lot in question, has a little more than it's supposed to. The rest all have what they're supposed to. It's usually a bigger problem if they have less in those cases. So I feel pretty confident. I'm sure all surveyors do, but I feel pretty confident in our survey.
So let me see if I'm straight here. You don't really have an objection to their addition. It's a matter of settling on what is yours and what is theirs and what is right. Am I correct in that assumption?
Me, I object to the addition because they haven't gotten a survey. What I object to, I don't object if they get a survey and it's legitimate and they can contradict what he said, but based on our survey, it shows that the setback line is further back than what they're saying, and the right-of-way line is actually further back. So I'm not a surveyor. I don't know. I just know that they keep building up a property that has a very small amount of space, and we haven't resolved the other issue. And I just feel like, I just wish they would actually get a survey so we could discuss this and move on. That's what I'm trying to get resolved.
I understand. I guess I'm asking you, if they're within their limits, legal limits of their property, you don't have a problem with it, correct?
If it follows the legal limits and they have a survey that shows that they're complying with the law, then yes, I don't have a problem with it.
Okay. Anything else to add?
Do you have anything?
We'll have to come back up for their 12 minutes rebuttal time, and they can address the issue of why there is no survey.
Great, thank you.
Thank you.
Okay, I guess the question here is why has there not been a survey done?
We have met with Barge and Wagner. We did it right after this request, and we're kind of on their schedule. We're supposed to meet this week. The vice president we're supposed to meet with, she was out of town from last week until yesterday. Before then, they were backed up on projects that are more pressing. So we're in the queue. They just haven't gotten to us. They have a little more experience in this area, in this part of town. They surveyed the area all the way down by the train tracks. And just preliminary findings are that what's on the plat is not the way it is in real life, that there were discrepancies back when the plat was made. And I personally made a report outlining why this is their second survey, because their first one was found to be in error. And I personally made that report, presented it to Barge and Wagner. They thought it was pretty good. They offered me a job, so that was flattering. But just showing that there were mistakes made. People are fallible and corruptible, but either way, mistakes were made. We presented that report to them showing where the real property line is. We didn't hear back from them until the second survey was introduced to you guys at the last meeting, kind of like they had just gotten it, even though it was stamped 2 days before the meeting. Their first survey was done last June. They didn't send it to us until mid-November, and I have the letter here if you want to see it. That doesn't seem to be in the spirit of honest resolution. Personally, this is my personal opinion speaking for me, it's a shakedown. They've offered to sell us what's there for $30,000, or they've offered to buy our lot for $75,000. It is their intention to keep the two things connected, so that you guys are forced. They force your hand. They force our hand. It's leverage in a legal sense. But we've shown on their survey, and I work in AutoCAD all the time. We've shown on their survey our addition, and there is no encroachment. That was their initial objection, is that we don't know where the addition's going to be, so we can't say yay or nay as to whether or not there's an encroachment on the new addition. There's definitely not on the proposed addition. There's no encroachment there, and so now they've kind of like shifted gears and are, I guess, I don't know what the argument is against it now. One about traffic, where you could see our addition would definitely not interfere with anything. If anything, it would be the aesthetically offensive warehouse next to us. But that was in their right. They were in their right. They were legally allowed to build an addition. And we're just asking for the same treatment.
So I'm confused. How is it that, why are you saying their surveys are wrong if you don't have a survey?
Because it doesn't add up. And I mean, I don't want to bum you guys out the way this has kind of like bummed us out all winter, but the frontage down the alley does not equal the frontage on the plat.
But that's not just his opinion. Barge Wagner.
Yeah, I mean, this has been reviewed by professional engineers.
So bring us a survey and tell us that.
We're definitely working on that.
We're trying,
but the time frame is what the time frame is, and we prefer to meet here today to present our case because we see it as a separate issue, and that the survey is outside the bounds of this discussion.
I don't think it is a separate, because it goes to the veracity of your information on your drawings, and I make it a policy personally not to vote to approve or disapprove something that I can't see. If someone is asking for a height variance and they bring me a plan, and they said, it's only a 3-foot height variance, and I'd like to see it, draw me a section. And this is such an easy thing to allay this issue with me anyway. I'm not even saying you have to have a resolution between the two surveys. I mean, we're smart enough people that we can consider the evidence as it is, but you're contesting something that I feel like is a legitimate complaint with no evidence.
Well, we certainly respect that, but at the same time, Mr. Francis was up here for quite a bit of time discussing his concerns, and he clearly said that he doesn't have an opposition to the addition if it does not cross his property line, and they had no evidence to show that it did cross the property line. And to my understanding, a survey is not required for the proceedings here, and the data that we are showing is accurate to the best of our knowledge at the time based on the deeds.
Surveys aren't required for the proceedings here, but what is required for approval of a request is that you show the commission the respect of either answering their request or deferring, and not arguing and telling us what we are to or are not to consider, and saying that they have ulterior motives, whatever. The point is, you have a neighbor on a third of your property lines that is in opposition to this, as is, and that opposition has said, I will not oppose it if you can just show me that the information is good. And I think that's an easy request to fill.
And Mr. Harper, I'd just like to refer back to Mr. King's question about, really when he underscored how surveys can go back and forth and say different things. And that's pretty much where we are at this point. They had a survey. My husband found parts of it to be in error, and Barge and Wagner agreed with his assessment and signed off on it, basically saying that that first survey of theirs was in error. And then they've come back, after we disproved the first, they've come back and set with a new one. So basically we're in a pendulum swing of they present a survey and then we have to present the error. So now we're back in that same swing and we're going to have to disprove this new survey as well, which will be done. But we've already disproved one of their surveys.
And I guess that's why we're showing the worst case scenario is their site plan, is their survey, and there's no encroachment on worst case scenario, which is their survey.
Assuming that your information is correct. If you're showing the existing buildings and
well, that's
your
their
addition
survey.
in the correct space.
What matches the site plan.
Excuse me, the opposition testified they did not survey your structures on your property.
I think this may be more simple than we're letting it be. I think you're not trying to build on property that is not yours, are you?
No,
we're building on our property.
You have no intent of doing that, do you?
Correct.
No, sir.
So your intent is to get a survey and abide by the survey?
Absolutely.
Okay. I think that's the merits of the case right there myself, so I have no further questions.
And I agree with that, and I don't have to count noses to know that you're not going to get 4 votes to approve this without a survey. So it's up to you whether you want to roll those dice and be denied or defer it and come back with a survey as we've requested.
I guess so.
I mean, what are you? I mean,
You're asking.
What are you asking? I think
what you're hearing is that there's not enough. I mean, I agree that with David that it was strongly advised to get a survey, and it sounds like you definitely went down that road.
We definitely tried.
There was also, I think there was also some thought at the time that we didn't need that at all, and that we could decide without that. I don't think you have the votes for that side of the opinion today, and so it sounds like, and I wish we could decide today personally, but that's not, I mean, we have a wide variety of opinions, and it's a good thing. That's good for the city and for everybody, that we cover all of our bases. But it sounds like you're not going to have the votes, and if you feel like you can get a survey before the next meeting, then it would be in your interest to probably defer to the next meeting rather than having us vote. And then I think the rules are if we vote, you get 2 votes, you get 1 vote, you get 3 votes, however many votes you get. If you don't get 4, then the others have to either listen to it and come back to speed and then vote next time, or a certain period of time you don't get it. It's, in these situations, it's a whole lot easier just to get your survey. And I think that's important for folks on the board. Is that fair?
Sorry.
That's fair to me.
Yeah, and I just want to make sure that is correct. On a non-majority, people can vote in the interim or by the next meeting.
Or change their vote.
Right.
Or change their vote.
The provision that you all are referencing is under 1740-240. It says 4 board members shall constitute a quorum, and the concurrence of at least 4 board members shall be necessary to deny or grant an application. In the event that 5 or more members are present, failure to receive 4 affirmative votes within 30 days of the hearing shall be deemed a denial. In the event that there are only 4 members present and there are not 4 affirmative votes, then the application shall be re-advertised for the next regular meeting. So even if you, even if you voted and you had 3-1, or you didn't receive the full votes, because there are just 4 of you, it would be re-advertised automatically.
So no one could weigh in after the vote to add their vote to it. That's what I want to make sure.
Yeah, I said something that was wrong. I said that they could come back because they had heard it.
No,
You
it
know,
would just
but
be
they'd already- I
re-advertised.
mean,
It'd be a whole new hearing. So I think anybody, you all correct me if that's not correct, but I think anybody could, at that point, since it has been re-advertised, it would be a whole new hearing.
Even though it was a deferred case where all 7 heard it the first time?
If it were deferred, now that's if it
This is
voted
what
down.
this was.
but
This
if
is a
it-
deferred case that everybody heard last time.
Right.
So could they catch up?
If they defer it again, then they would have to review the record in order to catch up from today's hearing, correct?
So if we voted and it was not 4 votes, at that point, no new evidence could be introduced until it's a new case. So the person or persons that voted against it could not change their vote after it's decided, since there's only 4.
I'm not reading that into.
Okay, I just want to make sure
I can't read that into the law, but I think that by the fact that it's re-advertised, it becomes a whole new hearing. So
No, I'm saying it gets re-advertised if it's voted down.
Correct.
Either way, is what you're saying. I mean, if it's not approved, if they don't receive 4 votes, it automatically gets re-advertised.
correct, because of the fact that there are only 4 of you today.
Okay. I knew there was something different about 5 versus 4 and what happens. I mean, but we can discuss this.
Can I ask just a few questions?
Sure.
So if we get a survey and it disagrees with their survey, in our favor, presumably, then are you saying you then still can't vote on it?
We can vote at any time. And I was floating that so that what we just discussed about what happens in the time schedule, everybody's fully aware of that. My personal opinion is I am not opposed to the addition. I'm willing to grant it, given, and I'm not arguing the opposition's case. Don't read that into what I'm saying. We just happen to have similar concerns. And, if you had a survey that showed you're okay, and they agreed with it, even if it disagrees with their survey, that's what he said. It's like, if there's a survey and it says that they're legal, he has no problem with it. That's all I'm asking for. Right now, we don't have that survey that has all the information in one place.
So are you proposing they survey and then also add the addition to the survey? Because the survey is not there. I mean, the addition's not there, so you wouldn't be able to survey an
No, right.
existing,
That's what I'm saying. I mean, as you've done with their survey, if your surveyor says the house is here are the property lines, everybody's happy. To me, it doesn't even matter if your existing structure is over the property line or not. Just get a survey.
It's not unusual for an architect or civil engineer to draw a new addition onto an existing survey.
Yeah.
And that's what we've done because that's what we've done because he is our architect.
Which is what we've done, but I'm not licensed as an architect, so it's not stamped. And I understand.
But what I'm saying is
the concern for
their
stamped.
surveyor, you're using his survey, his information from his survey, and he testified that he did not locate.
He refused to do that. We asked him.
I want to make.
We asked him to draw it on there, and he refused to do that. And he refused to share the digital file of the drawing.
What I heard.
Maybe I misheard.
We may get into discussion, and I would almost recommend that asking if this were deferred to the next meeting, can you get a survey by then? If that's the hang-up with
I
us?
can't speak for Barge Wagner's schedule. Is kind of the bind there, and so
That's absolutely our goal.
And so we showed worst case scenario. They refused to share the survey with us. And so he said he would not put our addition on their survey. And that was the request of the surveying company we've talked to. They said, talk to John, he should be able to put it on there, and he refused to do that.
Well, hang on a sec, because maybe I misunderstood what he was saying. Is the existing structure, and I get, we can ask the surveyor, is the existing survey or the location of your existing house on the survey? Was that surveyed?
That was the existing house was his survey, and then we put the black block in there.
Added the addition.
Right. That's all we've added on to his survey, just to show that there was no encroachment, because that was their claim.
Okay.
Okay, let's close the public hearing.
Just as far as procedure, though, I mean, will you guys tell us after you talk what our next steps are? Okay.
I guess to me, I mean, I feel like that the non-conforming issue is to some extent settled through the neighbors' letters, and they're substantive and in a great variety. So I really have zero concern about that criteria of this item D appeal. And I really almost go back to, and I'm really sad every time I see line disputes and property disputes, because I think it's just unfortunate, and it feels like it just breeds ill will and bad blood, which I think is evident, and in almost every case that happens. But I also think that since their surveyor and the opposition didn't object to this addition if it met the criteria, the survey that the appellant put, seemed to be the opposition survey with the addition not encroaching. There was concern from the opposition that it encroached, that it didn't meet one of the setbacks on the side, but not the setback on their property. So I would much rather this go to another body to settle those disputes. And if it weren't for that property line dispute, I think this would have been on a consent agenda, so I think that we should approve it, let the property disputes go other places, but also approve it with a note of acknowledgement to the appellant that they should probably provide codes with the survey that shows that they can build in the footprint that they do.
We can put that as a requirement.
And I would almost put that as a requirement that says, they need to present their own evidence that says this isn't requiring any kind of setback, and if that's the case, then I'm okay. I think it meets the concerns that you're asking for next time.
It does. I mean,
but
I would approve it with that condition that.
Well, then I'll make a motion that we approve the item D appeal, provided that the appellant provide codes, a survey that satisfies codes that they are not requiring anything other than the item D, that they are building within the legal framework they're allowed to build.
I fully agree they need a survey, but can we tell them they have to get a survey legally?
I think we're saying that they have to provide evidence to codes that satisfies codes.
But we have the authority to order them to have a survey?
The code allows you to impose reasonable conditions on the granting of non-conforming uses, variances, and special exceptions. To the extent that this is tied to the property and your desire to make sure that you are not causing any harm to any neighboring property or increasing the degree of nonconformity and making sure that it is consistent with the FAR that is required in the zoning district, then I think you could impose such a restriction. But it has to be tied to something that is relevant to your decision too.
We can't tell them to paint it pink and we'll approve it.
I'm
sorry? We can't just say paint it pink.
Yeah.
Right, correct.
What we're deciding.
Correct. But since the appellant has said that it's in the works, they plan to do it, it's important to them also. So I mean, this, in your opinion, that criteria would, or that condition would meet what you just said we had to meet?
Well, that's kind of the issue for the board to decide. I mean, if you find that that's what you need in order to render your decision on in those areas, then you can require that. But that would have to be a finding that the board makes that that's what you need.
Well, and it clearly
that would have to be reflected in the record.
Well, and I don't think this is our business, but their survey would clearly help continue discussions between them and their neighbor, which. I mean, I imagine both sides would love for this to be resolved as I would hope both sides would want it resolved as quickly as possible, just so they could get on with living next to each other in a more pleasant way. But I would make that motion with the condition that they provide codes with adequate evidence that they're not violating any other code requirement than the item D requires.
You might want to phrase that in a complete motion. Our secretary was looking a little concerned there when that you would propose. You said I would move that.
I made a motion a little while ago. It didn't get a second, but I made a motion that said
that we approve.
I moved that we approve the item D appeal. Y'all listen closely and advise if I get it wrong. On the condition that the appellant procure a survey or other document necessary for codes to determine that they are building a legal addition to their property.
You all are looking at me because I have a question on my face, and the question is, I'm trying to determine what is it that the board wants codes. I'm concerned about the position that the board is putting codes in. I'm trying to determine what is it that they want, that you want them to find.
Here's the thing. I mean, if codes, we approve setbacks all the time. 10 feet to 8 feet.
Mm-hmm.
And somebody at codes has to, at some point, when they give a final approval on the project, say, yeah, it was 8 feet. And if it was really 7 feet and they stole a foot, then they got to come back to us. And if code says, hey, it's outside this kind of margin of error that we're allowed to deal with.
Okay.
And so what we heard was that the opposition is concerned about a 15-foot setback being true. And the appellant said, no, we're building right. And we heard the opposition say, we don't think there's a problem with the back on our property side, but it'd be nice if they showed something. And the appellant said, no, we don't have any problem with the back because here's their survey and here's our lot, and you can see that there's no problem. And so the question is, what do you take to codes to say, hey, I've got a right to build here? The zoning board approved the item D part, but we need not just the opposition's survey, but we need something from our own.
Okay, and that being said, and I was just hearing from Mr. Herbert also, but would you share that with the board? Because I think that's the question, is what we probably need to hear from codes as to what is it that they would require, because that may be something less than a survey. So I don't know in that instance if that's the direction the board really wants to go. So
we require a scaled site plan showing the location of the property boundaries, where the buildings are going to be located. From that scaled site plan, we make sure that the setbacks are what is required by the code. And typically on the front of the permit that we issue, we will say what the setbacks are. So in the event that something is constructed and it's constructed within the setback, the applicant is on notice because it's on the face of the permit. Your side setback is whatever it is. So that's what we require, is a scaled site plan showing the location of the structures on the lot relative to the property lines.
Have a bona fide site plan.
Well, my issue goes back to the survey. I was okay with your motion right up until you said, or some other document.
Then I will say, they're good with a survey. I'm good with a survey.
Yeah, that's all I'm saying. Just like provide a survey, and then they, once they have the survey, their site plan has to be correct.
In an effort to get a second on a motion, I will say I will move that we approve the item D request, provided that the applicant bring a survey that they have conducted as part of their application to codes when they apply for their permit. And that codes is satisfied that their addition does not require any further variances. If it's out, it's out.
I'll second that. I'm through discussing.
All in favor of the motion, say aye.
Aye.
Opposed? Passed.
Fifth time was the charm.
Well, thank you very much.
Thank you for your time.
Okay, we're going to take a 5-minute break and we'll resume in 5 minutes. Of the property located at 1103 Nickel Lane, requesting a variance in the street setback in the R20 district to reduce street setback from 48.5 feet to 37.5 feet to construct 2 new townhomes. Referred to the board under section 1712.030, the appellant has alleged the board would have jurisdiction under section 1740.180B. So we got Mr. Henry here at the table for the appellant, and we will go ahead and let Mr. Harrison proceed with our department's PowerPoint presentation on this, and then we'll hand it over to Mr. Henry. Both sides in this case will have 15 minutes, and the applicant can reserve a portion of that 15 minutes for rebuttal, and the opposition will have a total of 15 minutes for the reply to Mr. Henry. So, Mr. Harrison.
Subject property is located on the west side of Nickel Lane. Shows property here across the streets from Belmead. Behind it is Metro. This is an aerial photo of the subject property. This is the plan that has been approved prior to with the 37, no, this is what they're applying for is the setback variance on this one here. Shows a site plan for the setback variance with the garages. This is the existing house that faces Nickel Lane. Subject property. That's property to the left on the top picture, property to the right picture. And that's the photos that we have.
Mr. Henry, are you prepared to go forward?
Yes, sir.
It's all yours.
Okay. Mr. Chairman, members of the Board of Zoning Appeals, my name is Sean Henry, 315 Dedrick Street. I'm representing Mr. Sidwell. Mr. Sidwell is here with me, as well as his team, Preston Shea, sitting on my right. Michael Dewey is the engineer with Dewey and Estes Engineering. Kevin Didillo is the builder with Ridgemont Homes, and he's the one who has applied for the building permits. Let me first say that we are asking to amend our application. We've gotten further clarification on exactly what setback our client is asking for, and so we want to amend that request from the 37.5 feet that's requested to 38.4. So instead of roughly a 11-foot variance, we are asking for roughly a 10-foot variance. And I'll explain that in a little more detail in just a few moments. This property is zoned R20, and as you can see from the slide that's on the screen now, it has a site plan that has been pre-established through the Horizontal Property Regime Act. Those footprints are presently of record in the Register of Deeds office because the property is zoned R20 and you can have 2 homes on a single lot. And this is not a unique situation for this west side of Nickel Lane. In fact, this property, this site, is one of 24 lots on the west side of Nickel Lane that are similarly zoned R20. They all could take advantage of the ability to build 2 homes on those lots. Procedurally here, what my client has gone through, 2 years ago, Mr. Sidwell acquired the property through a public foreclosure process. and I emphasize public, there could have been other folks who have purchased this, and perhaps even folks from the neighborhood, but nonetheless, Mr. Sidwell acquired the property. Mr. Sidwell grew up in this neighborhood, in fact. Upon acquiring that property 2 years ago, in September of 2013, he obtained his first survey of the property, and this survey, prepared by surveyor John Allen Hood, it's dated September 19, 2013, established the average setback of 38.4 feet. So, prior to May of last year, the way average setbacks were determined, and it's part of the contextual street setback provisions that Metro adopted some 10 years ago, but the way prior to May of 2014, you simply look at the setback that's permitted on the property and look at the properties on either side of you, the two homes on either side, and arrive at an average setback. So that was done and arrived at 38.4. As you can see on the aerial photo, the properties to the north, that's the Bellbrook subdivision. Those homes have their orientation internal to their development. That's a PUD. So the rear of those homes actually back up to Nickel Lane. And that particular subdivision was platted with a setback along Nickel Lane of 20 feet. And we'll offer for the record that subdivision plat. So as you come down Nickel Lane, coming from the north of the slide, where the rear of those homes in Bellbrook can be as close as 20 feet to Nickel Lane, you then come down to this subject property, and we're asking for the setback at 38.4, and then you transition further down the street to these homes that are existing. So I'll just tender for the record the survey exhibit that established that 38.4 feet, which is based on the setback of the existing property and the adjacent property.
Mr. Henry, I'm sorry. To go back to your point about the way it used to be measured, the average, please tell us how it is measured now.
Yes. And so effective May 23 of 2014, the Metro Council enacted Bill number BL 2014-725. This bill established a new way of measuring the average front setbacks. And it says that the average setback will consider the four nearest single-family or two-family houses on the same block face that are oriented to the same street and that follow the established development pattern. So now, as of May 23, 2014, the setback is determined by looking at the four homes to the south. Again, the homes in Bellbrook are excluded because they have rear orientation to Nickel Lane. You come south to the nearest four homes, and you arrive at a setback of 48.5. And I believe that's in the record, but nonetheless, I'd like to just tender that particular survey exhibit as exhibit number 2. So 38.4 was the prior average setback. Since May 23, 2014, the setback average is 48.5. And that was a surprise to my client. They got underway with this early in 2013 in doing the site analysis and trying to determine, how to position the homes on the property, and ultimately put to record the horizontal property regime, which was compliant with the prior average setback. My client went ahead, maybe concerned that the variance being requested will not be granted, went ahead and obtained permits to build pursuant to the average setback, which is 38.5. So he presently has permits to build the two homes, and I'll just, for the record, permit number 2015-01497, that's for home 1103A Nickel Lane, and then permit number 2015-01500, that's for the home that is addressed 1103B Nickel Lane. So he presently has permits to build the two homes compliant with the 48.5 setback, okay? So if this variance is not granted, he has permits to move forward to build two homes on this property. The variance request is largely based on two factors. One is the irregular shape of this lot, as you can see in this aerial photograph. These lots were created in 1928 as the Highlands of Belle Meade, and that was a plat that was recorded then. And I know Mr. Harrison has that in the record, but I'll just offer it here anyway as exhibit number 3. And what this depiction shows is the curving nature of Nickel Lane. And with the approval in 1982 of the final plat for Bellbrook, immediately to the north, there really is no other lot of all the homes as you come south on Nickel Lane. There's no other lot on this side of the street that has a side yard of that dimension. And you see here, it's the side yard is either 196 feet as shown on the Bellbrook plat, or it's 175. It's somewhere in there. But the point is that side lot line is longer than any other side lot line on this street, and thus you get this curving nature of the lot. You get an irregular shaped lot that has created difficulties for the footprint of the building envelope footprint results in a skewed nature. And just for the record, I'll offer up this final plat of Bellbrook that was recorded in 1982, and it shows that it has a recorded setback of 20 feet. And interestingly enough, I think what you may hear from folks who are concerned about this, one of the things is the concern about two homes being on this lot is too dense for the neighborhood. The Bellbrook subdivision approved in 1982 is actually more dense, right at 3.9 dwelling units per acre. It's more dense than the two homes that my client's proposing on this property. Councilman Carter Todd spoke to you a minute ago, and he's correct. We initially deferred this case from the prior agenda, prior docket, in hope that we could flesh out the concerns that neighbors might have. And we met on site, and we were talking about a variety of things, but the primary thing we heard, and perhaps you'll hear today, is they really just wanted one home on the property. But Councilman Todd talked about transition and step down. If we could go back to that aerial photo, I would just like to point out again that the idea that this is jutting out into the street, that it's an abrupt change in the character and context of Nickel Lane, really just doesn't play out when you compare the backs of the homes in Bellbrook as you travel south and you see the proposed homes, and then they do transition very effectively down to the single-family homes that are there. So we just have a disagreement there. And in summary, that Bellbrook has a 20-foot platted setback off of Nickel Lane. The base zoning for the subject property is really 30 feet. Base zone R20 is a 30-foot setback. But when you factor in the averaging provision, prior to May 23, it was 38.4. Since May 23 of 2014, it's now 48.5. Our request is to allow these homes to be built in accordance with the prior setback averaging provision, which is 38.4. Mr. Shea can speak to the real benefit of that, but very succinctly, what's at issue here is whether the garages that are at the front of the home are either going to face Nickel Lane or are they going to turn sideways if this variance is granted, and those will become side-loaded garages.
I've got a quick question on that. Before you get to that, I think you're going to talk a little bit more about it. But can you address I understand that the shape of the lot, I understand your points about the curve, but what I'm struggling with now is that if you have a permit that's already approved for building two homes, I'm not sure how the hardship argument holds since you already approved to build the two homes within the current setback. And so I want to talk that through a little bit more so that we don't get into the argument over aesthetics, because if it were my street, I might prefer one of the two versions versus the other, but I have a lot of people who live on the street coming to tell me their opinion in a minute. And so help me understand it from a pure hardship perspective, why request that you're asking for is something we should consider when you have another option.
Well, I think this is a good time for me to stop talking and let Mr. Shea speak to what they've been through on the property and the site fit testing that they've been going through. So,
thank you. I am Preston Shea, President P. Shea Design, a residential design firm in Franklin, Tennessee. We were hired to do the studies and follow up with the full design of the homes at the subject property. I have a few more exhibits. I've got 4 copies for the board. I've got several copies that I would love for the neighbors to look through if they may. The contextual overlays, zoning, setbacks, pretty much anything we do at its core is either health, safety, welfare, or aesthetics as far as setbacks go. So we do feel that the hardship in relation to the building setback is an aesthetic issue. Our clients originally wanted, and this would be on the first page of the 3 pages I handed out, originally wanted to put the garages in the rear yards of these houses, and those driveways would cross this drainage area, and Metro Stormwater denied that request. So we had to go back to the drawing board and redesign these in such a way as that the entire home is in front of that top of bank. So on the second floor, or on the second page, what we've come up with are 2 homes that are in front of the top of the bank that do comply with today's standards, and what we're left with is 2 front load homes. And so those are the homes that have been permitted and that we can, or our client can go ahead and start building. We are simply asking to go back to the previous method of calculation, which is illustrated on the 3rd page of the packet I handed out. It is better from an aesthetic standpoint, in my opinion. Has the garages facing sideways, and if we looking at the aerial still on screen from a land planning aspect, I also hold position on several design review boards, was on the Historic Zoning Commission in Franklin, and if out of context, I would want these 2 homes to stagger forward to break up the abrupt shift between the existing streetscape and the new development to the north. So our hardship is nearly 50% of our building envelope is taken out of play by the creek. And being as setback requirements, everything at its core is what's best for the street, what is most visually appealing. We feel that getting the original, or I guess the formula that was in place when our clients purchased the lot, is the appropriate way.
Can you tell me a little bit more about that creek? You can't really see it on the drawing, and it looks like, according to the drawing, it goes straight into that. Whatever the subdivision is,
it does.
I can't read.
Bellbrook.
Yeah, Bellbrook. Yes, thank you.
It does.
I need reading glasses to see some of this sometimes. But yeah, so, and I understand you've been working with stormwater and that kind of thing. So, and I understand a creek through your backyard is a hardship that this board is often respected as a hardship. But tell me a little bit about when that creek is active and what it means to your property.
If we may, this is Mr. Michael Dewey. He's the project engineer.
I'm Michael Dewey with Dewey Estes Engineering. We worked diligently with Stormwater during the review of this project, and years ago this conveyance was determined to be a wet weather conveyance and not jurisdictional waters by Metro, and so we have the ability to to manipulate this stream, and this what we've gotten approved by Stormwater is to provide more capacity on this site for the ditch, and that's been our working with Stormwater to get that approved. And one other point is it was not necessarily denied by Stormwater. We to put the garages on the backside of this. They asked us to not cross that wet weather conveyance, even though we had the ability to, and our clients complied with that request and put the garages in the home.
I'd like for my client to make this part of the exhibits for the record, if we may. Oh, you do?
What is it? Is that a survey? Where are you entering it?
Hang on, ma'am. Please reserve your questions for when you're at the table.
This exhibit, though, seems to show that there's a proposed conveyance that the stream is moving. Am I reading that right?
Yes, it's a wet weather conveyance that's getting shifted.
Being shifted to the back, more towards the back of the property.
Yes, ma'am.
But just to be clear, and the proposed conveyance, excuse me, is what Codes has agreed to, or
yes. Yes, the grading plan has been approved and the grading permit has been issued.
So I don't want to put words in your mouth, but to clarify for us less engineer-minded folks, you can move it, but you can't do away with it. You can't ignore it, and you can't, according to Metro, you can't build over it. Is that right?
That's correct. Yes, we still need to provide safe conveyance of that water through our site.
And I'm also assuming, please tell me if I'm wrong, but looking at your drawing, you do not have control, or do you, of where the conveyance enters or leaves the property, correct?
That is correct. We can only touch our site.
What are the sizes of the homes, square footage wise?
Approximately 4,200. The gentleman in my office who actually has designed these specific homes, family emergency, he's in Louisiana today. I'm aware of the generalities, but.
So they're roughly 4,200 square feet each?
Approximately.
And those are the homes that are proposed, and what are the homes with the garages that face the street? Are they the same?
I believe they're going to be a little bit smaller. The exact number, I'm not sure, a couple hundred feet each, maybe.
Is the water feature at the front of the property, is that stormwater related, or is that aesthetic?
Yes, sir. It's stormwater related. It's a bioretention area for water quality.
Any other questions from the board? Anything else to add? We have
Just finally, Mr. Chairman, we would certainly like some time for rebuttal, but just quickly on your standards for a variance, we think we've satisfied those standards. The physical characteristics of the property we spelled out, the creek and the irregular shape of the property. This hardship's not self-imposed. It's not been created by the previous actions of any prior person. Financial gain is certainly not the sole basis for pursuing this request. There's no injury to neighboring property. We heard testimony from Councilman Todd. You're about to hear some additional testimony. We're happy to address those points. But the idea of property values going down as a result of this, we're talking about hundreds of thousands of dollars of investment here by my client. We don't think there's a detrimental effect to the public welfare here on this street. So with that, we'll conclude.
Okay, you'll have 1 minute and 4 seconds left for rebuttal.
Thank you.
Okay, if the opposition would like to come up, and I'm going to take the exhibits that were passed to the board and I'm going to put them on the table for the opposition so that you all have a fair opportunity to review those as well.
Oh, that's what it's in there.
Good afternoon, ladies and gentlemen of the board. Thank you. I'm going to have to leave, and so I'd just like to thank you for the opportunity to speak. My name is Laurie Jewett, and I actually live to the left of this property on Nickel Lane. So we're this, and I'm not very good at this, but this is 1103, and I live to, if you look at the house, I live to the left. I'm in that little white house to the left at 1105. And I've been there for the last 18 or 19 years and have literally known everybody that's lived in that house for the last 20 years. And there have been several people. And I was there in the flood of 2010, as we all remember if you were here in Nashville. And we got hit very badly on Little Nickel Lane. And I think that's why you'll see that so many people are here today. It's a very close street, and it's a very sweet street. And I've been privileged to raise my children there for the last 18 years. The street's been really good to me, and that's why I'm here. Unfortunately, my own docket, I have 60 cases set at 4 o'clock, so I've got to leave and go out there for that. But it was very important for me. I had my property surveyed, and I'd like to thank the property owner. I believe that Mr. Henry, who is the lawyer here for the appellant, it has been lovely to me. I would like to thank him. The builder has been lovely to me. They have been very kind to me. I don't know the architect, but I just didn't want them to knock this house down and build right next to me, you know, because what they're doing, in my opinion, is, and this is not as a lawyer, this is just as the little old lady who lives next door. I mean, and I've been there, and is there this lot, when he says 50% of it's been compromised, well, they knew that. I mean, the creek takes up 50% of the lot, and he bought this out of foreclosure for $365,000, you know, on this street. He knew that it's a risk, and they're going to put 8,400 square feet of houses, 2 houses that are 4,200 square feet on this little corner. They're going to squeeze it in there on this little street. My house is 2,200 square feet next door on 21,000 square feet of a lot. I don't know how many square feet they have. You have their survey. I had my lot surveyed. I had a monument search. I don't even know what that means. And I'm going to leave that with my neighbors to introduce to you. And please give them a copy, Mr. Henry, because we're going to swap surveys. We just haven't had time to do it because I don't want to get on their property. And I don't know if they agree or not, because I heard you go through that whole case before me. So here's my survey, and y'all work all that out. But I'm just trying to tell you from my opinion what I think is going to happen. That flood was massive there. And Bellbrook got flooded. I got flooded. You know, you put 4,200 square, it's legal. He can do exactly what he wants to do, and I told him I'll bring coffee to your contractors. They're nice people. It's really not my business. But do we want it? No. And that's my opinion. Thank you for listening to me. And whatever you do, good luck. And thank you all. Bye-bye.
All right, so as you can hear, that's Judge Jewett, and she lives immediately adjacent. My name is Angie Henderson, and I'm president of the board of the Belmead Highlands Neighborhood Association. So we represent all the neighbors on the west side of the street. I have 17 neighbors that were able to attend with me today in opposition, and many more wanted to be here. I believe you'll see in your record 30 or so wrote to you with their opposition. Ms. Jewett, again, is immediately adjacent. Mr. Coble, who lives directly across the street, he was here to speak as well, but has had to leave due to time constraints. Judge Jewett mentioned her survey, her monument survey. We still have yet to receive, though we requested when we met well over a week ago, I guess 10 days ago now, the survey for the appellant. On Monday, there was an email saying, so, you know, this parcel is 0.53 acres. I believe it can be split in half at 0.45. And, you know, so I think there's a little bit of question around the potential for conflicting surveys. As Judge Jewett alluded to, there are some acute stormwater concerns. And also, I would just like to kind of put this in context. I know Mr. Henry spoke to the Bellbrook subdivision being there, but that subdivision faces internally. It's situated on West Tyne, and really, you know, the character, the setback of the street begins with this parcel, but has already initiated further back on the opposite side, as Councilman Todd alluded to, on the City of Belmead side. So that's all single-family zoning on the opposite side to this parcel. So those homes are all very well set back, and all other 24 homes down the street are comparably set back. And I think that's really some of the appeal and the value on that street is the very uniform setback, the cottage nature. Kids bike on the street, everybody can look down and see all the way down the street. So the street has very much appeal due to, and value due to the current setback. As well, I want you to know that this west side of Nickel Lane is a bit of an odd piece out. I think most neighbors, I myself was under the impression, our whole neighborhood of the Belmead Highlands went to RS20 zoning about 8 years ago. And at that time, the west side of Nickel Lane was not in our neighborhood. I think it has come into or been drawn into Councilperson Todd's district in 2011. So the fact that this side of the street was not RS20, yes, they are entitled. It is R20. 2 homes can be built there. But I think, you know, we have initiated the process on the street now because this impending development in this fashion was a surprise to neighbors. I think everyone had the assumption, and I know assumptions don't count, but that street was RS20, and the homes are of those small and cottage-like and well set back. The homes in this area are quite high in value due to the charm of the setback of the street and the fact, as Carter Todd alluded to, that the City of Belmead is directly across the street. So all the remaining 24 neighbors are moving ahead with the process to rezone the street RS20. You know, Mr. Henry spoke to the previous setback when the law was different, but the law is what the law is now. And our neighborhood and our board has been very firm in that we hold builders and owners to the setback because in so doing, it's fair for everyone. Everyone knows what the expectation is when you buy a parcel of property. You know that that is the setback. You know that there is a very big wet weather creek in the back. And in this case, because this home was bought out of foreclosure because of various issues and flooding damage, this site, I think it's important for the neighborhood that it maintain the setback as required by the law. Does anyone have any questions?
Yeah, I mean, I understand all of those points and appreciate them, and I think that it's clear if it were up for a vote, the street would love to have a single-family home there, and I think it's also clear that there will be 2 houses on that property, and so,
I think, though, what I'd like to assert, though, is because the home was bought out of foreclosure at $365, as far as the motivation, yes, they are entitled to do that, but I would assert that the appellant can garner an equal profit by building a very nice single-family home at this location. We've obviously, Mr. Henry said, we've discussed that, and that's not what they intend to do. But then I would assert that, on the standards of the variance, financial gain is a primary basis here for what they're trying to do. They're trying to cram as much square footage as they can into this place, and they're trying to do that by requesting 10 foot of variance in the setback to allow them to build more square footage and garner more financial gain. As well as to it being a unique characteristic, yes, the creek is obvious and significant, but that is the same for all other 24 owners down the street. Now, it varies as to its placement in the yard. It's in the front sometimes, it's in the back, it's a little further back, it's a little more forward, but it's not a unique characteristic to this property. Every single property on the west side of Nickel Lane is built in response to, frankly, the placement of this creek. And thus, that contributes to the character of the street because all these homes are really little cottage-style homes because they were constrained by the creek. So here, by requesting the setback variance and garnering those 10 more feet to, build more, I think they're just trying to max out, the space that they can to garner the most profit.
Do you not concur that they can build, they have a permit to build without a variance with the garages in the front?
I concur that they do. I also think it's interesting that they brought these plans today to share with neighbors, to show, look how lovely the ones with the side-facing garages are drawn. Aren't those pretty, those elevations? And look how the ones with the front-facing garages are drawn. I mean, I think they're kind of holding this out here, like, give us the variance that we want, or, the very well-mannered kind threat is, we'll make front-facing garages. So I think, the same aesthetic talents that Mr. Shea has to build side-facing garages, I have no doubt that his talents and his ability as an architect, that he, I think notoriously people think, oh, front-facing garages are so horrible, but it is all in the talent of the architect and how they do that. My garage doors are front-facing, albeit them farther back and nicely trellised and wooden doors. I mean, it can be done in a charming fashion. Even if these garages are side-facing, they're still front-loaded, right? So they're asking for 10 feet in front to build closer to the street, and all that 10 foot in the front is garage, albeit side-facing. It's garage. So you can drive all over Green Hills and see quite a few of these now. Really big homes with front-loaded, or front-loaded to the property on the front of the house with a side-facing garage. And it's frankly not any more aesthetically pleasing than the ones that are front-facing. And so knowing that this was a potential if we were to oppose this. I did speak with Ms. Jewett, Mr. Coble, who is facing across, and I shared with them, if we oppose this, there's the potential that you have that front-facing garage. And they said they understood that and that they were still opposed. Our board still understands that because we want to be firm and fair in our opposition, but really our opposition is more an affirmation of what the current law is. And that requires this setback. And we think it's important for the character of the street and for property values that be maintained.
So you're really opposed only to the setback distance, correct?
That's why we're here, right?
All they can be.
That's all we can talk about today. So you have 30 letters from neighbors that are opposed to it. You have 17 folks here today, some of whom have departed. But yes, we are here in opposition to the requested setback.
All these folks here are opposition? Everybody in opposition, raise your hand.
You raise your hand.
Anyone else want to speak? Yes, a minute and 49 seconds left.
I don't think I have anything else to add.
Okay.
Is it not possible to bring up the issue of the water? We have a serious problem with water.
Could you come to the table and give your name if you have a question, please?
I think what neighbors are wanting to share some of the concern around this building. As I've shared with neighbors, they're entitled to build too. There has been in the last few years, over $250,000 of storm damage related to this creek and flooding. This is a notorious location for flooding. And so, that presents, just from a context standpoint, something about which neighbors are concerned.
I'm Alice Weaver. Thank you. I'm Alice Weaver. I live on Nickel Lane, and all of the Nickel Lane residents have a serious concern regarding the storm water runoff. The flood of May 1st, 2010, while devastating many areas of Nashville, was a huge, immense and enormous, overwhelming devastation of the west side of Nickel Lane. One person here sustained $100,000 worth of damage to his property as a result of the flood. And when you add up all of the people who were negatively impacted by the overflowing creek that they have referred to as quote unquote a ditch, that is really not a ditch. It has been a true running creek for many years, and that is a significant issue. We're concerned about structures being so big and displacing so much water that it will cause problems of the backup of the creek.
But we do recognize that they're entitled to build too, and the reason we are here today is in opposition to the setback.
All right, fellas. Why don't you come back up for rebuttal? You have, wrote down here somewhere a minute.
We'll be brief, Mr. Chairman. Again, we've got a lot here that is uniquely shaped compared to all the lots on Nickel Lane. This particular north side yard line is 196 feet deep. It's 26 feet longer on the north side than it is on the south side lot line. You really have a parallelogram here. And as a result of the creek and the unique shape of this property, we think we qualify for this hardship and the variance that's requested. I want to just comment, the comment was that Mr. Sidwell should have known what the setback was when he bought the property. He did know what the setback was. The setback when he bought the property was 38.4 feet. He submitted plans for that, and we have confirmation from that. But of course, on May 23, that setback changed while he owned the property, while he was pursuing his permits. The idea of financial gain here is the sole basis. That's not true. The real question here is which design ultimately here, either garage doors facing the street or garage doors facing the side yard, which design is more compatible with Nickel Lane? I mean, that's ultimately the test for what we want to look at here. What's most compatible for the neighborhood? And finally, on stormwater, the stormwater improvements that have been approved on the design drawings by Metro Stormwater is going to improve those conditions, those prior conditions. So I just want to make those points.
Thank you. Question?
I do think they need to build to current codes. And when we submit plans, when we submit plans to Metro codes, we're expected to build to current codes. And I'll have to say I'm an architect, so I go through this a lot. I don't think the creek is unique to that property because it goes through the other properties. And what I don't know is if they have the right to build 4,200 square foot houses. Like, is that their right to build that? Or I don't know if I'm explaining this right, but they could build smaller houses and stay out of the setback.
Yeah, I mean, everybody has different opinions on it, but my opinion is kind of like yours, just there are a series of constraints on properties, and we've heard cases before where someone will come and say, well, by right, I can build a 20,000 square foot building, but it would cause me to have so many parking spaces, and I can't get that many parking spaces on this lot. And it's like, well, then you can't build it, in my opinion, sometimes. I think that's one of those things. They might, by right, be able to build a certain amount of square footage, but if it causes other issues and other constraints, then they have to either come to us and we have to say, well, okay, or they just can't do it. So I think that we have historically looked at creeks. We've looked at demographic conditions as legitimate hardship. Certainly curves and roads are make it unique to the street, and I understand that. The issue that I'm having trouble with is reconciling that there's an existing permit to allow the property owner to build completely within the codes, which to me, and certainly has a permit to do that, negates some of those other hardship questions. I mean, usually we have appellants come and say, I can't do it, and this one didn't, because there are existing permits out there to say no. We have, I think I hear asking us to choose between two evils and getting to an aesthetic discussion. And while I may personally prefer Plan B, every neighbor on the street prefers Plan A. And the council person has come and said that in his opinion, and I'm not saying I prefer Plan B, I'm just saying that if I did it, I'm respectful of the neighbor's opinion. But we had a council person come too and say, in his opinion, based on the people that he represents, that this would be damaging to property values. And all of that to me is important. So I don't know if the neighbors are going to be happy with what they end up getting. I'm sure it'll be a beautiful home. Frankly, I thought both options were quite nicely done. But I haven't seen that compelling hardship reason to say that we should do this.
David?
I was thinking about the property value issue. That statement, I always find that to be a bit dubious, and it's a little like, it's a black art, I believe, predicting what property values will be if something is or isn't built. I wonder what the vacant lot would do to property values or a poorly built, smaller house. From my point of view, I was looking at the 5, 6, 7 requirements, and I guess it does come down to the irregularity of the property and whether or not that is a hardship, because I don't really see that it violates any of the other 6 items that we're to consider. I don't see the harm to public welfare, harm to the integrity of the master plan. I really don't see the injury to neighboring property. Financial gain not being the only basis. I don't know that any of the hardships were self-imposed. So I don't know. If any of those are negatively affected, I think it's de minimis in my personal opinion, in looking at what's here. And in context, I don't know that the 10 extra feet is. I don't see what the harm is, personally. It's sort of once you open the door to, either plan. I don't think the 10 feet is the issue. I think the size and density is going to be essentially the same. So I really don't see the variance is negative.
Anyone offering the motion?
Can we not say why 10 feet matters?
Well, I'm now sorry.
It's closed. I'm sorry.
Yeah, and I think we did hear. We did hear from the opposition. They spoke to that. So I think that it is on record why at least to some folks that were able to speak, why that matters.
What do you think, Chairman?
I could see it either way personally. I do tend to feel like there's a sort of move in this town to get all you can get on the lots. I see that as maybe a detriment to the neighborhood. I agree with that. But by right, they can build on there without this appeal. So that tends to tell me that there's not a hardship, that they could do it without the appeal. So
yeah,
they already have a better way the other way, That's why I'm on the fence on it.
Well, that's kind of where I am. Is if I want to impose personal preference, I might go one way. But if I want to just say, well, what are those topographical, and there's lot size and the shape and creek, is that something that keeps them from doing something? Then clearly not, because we've seen plans that show that.
Right.
And so that, like I said, we I don't know if our place is to decide the aesthetic question. I don't want it to be.
I don't think that's our place. But they are attractive homes, so I wanted to say that.
Yeah, I think unfortunately that is not our role. So with that, I will say based on the fact that they got a building permit to build within the guidelines of the code without a variance, I'd be hard pressed to grant a variance. So I would make a motion to deny based on that fact.
I'll second it.
We have a motion and a second. Is there any other discussion?
I have a procedural question to ask. So if the motion is to deny and it's not unanimous, then we have to hear another motion.
Repeat that, please. If the motion is to deny, I didn't hear the last.
If the motion is to deny and there's not a unanimous vote, would we
The
have
motion
to hear?
fails.
We'd have to hear another motion.
Correct. The motion to deny would fail unless there are 4 affirmative votes supporting that motion.
Right.
Same would hold true for the other direction.
Would it then, you would, but if it stayed, I think it.
But if the motion were to approve and it did not get a unanimous, then it would be dead.
No, because you have 4 members today. That would be the case if you had 5.
Okay.
But because you have 4 members, any motion that does not get the requisite 4 votes, the case will still have to go on and be re-advertised again, is the way I understand it. Is that correct? Okay. So the only way that there's any movement or any decision on the case today is that all 4 of you agree on something, either to deny or to approve.
Without that, just to continue on to the next.
That's correct.
Mr. Chairman, if I may, my client is fully prepared to defer here today so that we can see Ms. Jewett's survey that she presented here today, and she was not sure if they match up or agree with one another. We're happy to defer this decision for 30 days and compare our surveys and make sure we don't have a problem there.
If this is if let's say if we do vote and it doesn't get 4 votes one way or the other and it's re-advertised, re-advertised is a 30-day. That is a longer process. It doesn't just go to the next meeting, does it?
I'll have to yield the staff on how long it would take.
Without looking at the code, I believe that it says it's for the next available public hearing.
Okay. So what would be the next available hearing if we deferred it or if it had to be re-advertised?
If it has to be re-advertised because there's not the votes, then under the code it would be re-advertised for the next regular meeting. If it's deferred, though, then.
Well, for us to re-advertise it, because the advertising has already been sent out for May 21, the next meeting, it would then have to go to June 4th.
And that gets enough notice.
You said the 4th out today?
Oh, wow. And to clarify, it would be the next regular meeting, but now we're trying to figure out which meeting
is the next regular meeting.
Given the fact that the notices have had to go out for the meetings that are coming up.
So the meetings for June 4th meeting went out today. So the next one that we could notice would be for the June 18th meeting.
So,
but if it does not get 4 votes today, it goes to the next meeting automatically. Am I correct?
Re-advertised.
Unless we deferred it, unless we voted to defer it, it could go to the next meeting, but then you'd have to assume that the other members would catch up and hear so that there'd be a larger body of us to weigh in if we can't all agree now. So you're leaning toward.
Yeah, I'm in favor of granting it.
The deferral?
The public meeting is closed, please.
Can we not know why?
Can you please?
Ma'am, you're out of order. The board has the opportunity to discuss it, and they will, as a result of their discussion, publish their findings. It's required by the code.
I'm sorry, where were we? We were, yes, I am leaning toward granting it or voting against the current motion. But if we, I don't know if deferring will change anybody's mind or if anybody else would want to come on.
Do I need to withdraw my motion to defer it?
You didn't make that motion, did you?
We'd have to table
Did it get a second?
You made a motion to deny it.
There's a motion and a second.
And you
seconded it.
And, well, that's you can take a vote at this point, or you can withdraw. Either one. It's the prerogative of the maker.
But in either way,
if we take a vote, it doesn't defer it, does it?
it doesn't defer it, but it defers it until the middle of June and not to the next meeting. I mean, if David is thinking that it should be granted, and let's say it's 2-2. I don't know how everybody's going to vote, but I kind of do. Say it's 3-1, then it goes to the middle of June hearing because it didn't get 4 votes. If we recognize that and you withdraw your motion and we say let's defer it till next time, then it goes to the next meeting, of which only the 4 of us can hear it unless the others who aren't here watch the tape and join in on the discussion.
If one person joins in.
It took 2 years to figure out what all that worked, but I finally did. So that's kind of where we are. And
okay, I'll withdraw my motion. You'll have to withdraw your second, I suppose. So I'll withdraw the motion.
I would the next, when's the next meeting? The 2 weeks?
21st. 21st of May.
Okay. Can we open the public hearing for a second so we can ask if that's enough time?
We'll open the public hearing so you can ask.
Mr. Henry, would May 21st be enough time to review the
We're concerned that it may not be, and that's why I think June 4 would be preferable.
Okay.
We didn't have time to exchange.
Defer to June 4?
Yes, sir.
All right. Close the public hearing.
well, and the other advantage for everybody involved is that if we know it's going to come back and we defer it, then it will be first on the agenda, and that is good for everybody who's already had to sit through one of these.
And we don't have to rehear it.
We'll reclose the public hearing and.
I'll move that we defer till the June 4th meeting.
Okay, we have a motion to defer to June 4th. To a second. You dare?
Yeah, I mean, I don't mind voting on the motion now, but it just we will have to hear the whole thing again and at the meeting after that. So at this point, if they're asking until the 4th, doesn't matter if it goes until 2 weeks later. Is what I'm thinking is, and then you're kind of on record saying, well, this is what you got to do. So that I don't know. I flip the coin and see. I mean, I don't. It almost feels like it's better just to make your motion and vote. But the outcome is not going to be radically different.
I need to interrupt for just a moment. We're actually having a discussion with regard to the interplay between what's in the code and what's in your rules. There is some language in your rules that says after discussion by the members and upon a motion, an application shall be granted or denied if it receives four concurring votes. Then it goes on to say, in the event, well, is that the one we were looking at? Okay. And then we're trying to square that with what the code says as far as whether that has to be affirmative votes for the motion or if it has to be affirmative votes for the action. And so I wanted to make you aware that we're actually kind of having that discussion to the extent that plays into what you want to do. And I'm going to continue to look at that. But I wanted, because you were trying to figure out what is the effect of you're taking a vote today, depending on how that vote comes out, and we don't know until everybody votes. But that's something that we're trying to wrestle with really quickly over here.
It almost makes sense that it indicates or means the action.
Yeah, it's kind of reading it that way.
I don't guess it'd be proper to give the old Carol Barnett signal to our absent members today, would it?
If one person, if we deferred and one person, voted, that would give you 4 votes.
Well, I mean, yeah.
Or if they voted
I think we've come up with something. We've got 2 legal minds here working this out, and okay, this is how we've got to interpret it in order to give effect to both the rule and what's written here. If there are 4 affirmative votes to deny, it's still got to be re-advertised because it won't meet the prong that is necessary under the code. If there are 4, it won't be a flat-out denial. It'll have to be re-advertised. If there are less than that, then it would still have to be re-advertised. The only way there's some movement is if there is a 4-person approval. If there's a 4-person approval, then it's approved.
And so if there are 5 people here and 4 voted to deny, then it's denied. Is that
correct?
Okay, that's because there are only 4 of us
Because
here.
they're right. Everything is a little bit different today because there are only 4 of you.
So I'll withdraw my motion since it never got seconded, and we can go back to.
So I need to restate my motion?
Yeah.
Okay. I move that we deny based on my interpretation that it does not meet the hardship because there was a potential permit issuance already. Okay? Now a second.
I'll second.
And it's second. All in favor of the motion, say aye. Aye. Okay. Okay. Motion to deny is 4-0. Okay.
So at this point, it'll be re-advertised for the next available regular meeting. It'll come back. And it will be a new hearing. That's correct.
The appellant wants to do that.
That's correct, provided they want to do that.
Thank you. Thank you all.
June 18th.
He's done.
June 8th. Yes, sir. So everybody that's still here, the next available public meeting will be June 18th for this hearing.
That's provided that you here.
That is complicated. Because I had never read the color versus the rule.
I think we had Ford say no before. It was just no. I don't know. I don't think it's ever come out that way. Because it's always been unanimous ahead of time, and it's never been raised like it was here, where you had 3-1 in 2 cases.
Because it's 4.
I just saw Verity on 12 Angry Men. I was like, I was thinking about that today. It's like, you're not going to get it. I don't think you're going to change the 3 angry folks.
4 affirmative votes for any motion. I said 4 affirmative votes for any motion.
Well, that's the part that it's kind of argued, but for the purposes of this case, it didn't matter because the motion was to deny.
Yeah.
You know, so,
I'm just not going to vote against a council person and 30 neighbors. I'm not going to vote against a council person and 30 neighbors if there's that much, unless there's...
Have you all adjourned?
Yeah, I think so.
I don't think anybody, I didn't hear anybody.
Oh, then he usually adjourns us. Hey, Bill.
You want me to adjourn us?
Yeah, move to adjourn.
I move to adjourn. All in favor?
Done.
Adjourn. Thank you.